Welcome back to our Critical Compliance series. Previously, we discussed the DOJ's updated guidance on compensation systems tied to compliance. In this edition, we will focus on compensation clawbacks and how they intersect and possibly conflict with the world of employment law, as well as practical reality for many employers. The concept of a clawback is not new, at least for publicly traded companies. Since 2002, securities laws have contained limited incentive compensation clawback requirements for certain executive officers at public companies, and the SEC also recently issued a final rule on this subject. In addition, several states, including New York, recognize the common law faithless servant doctrine, which gives employers the ability to sue an employee for acts of disloyalty and to recover all or part of any compensation paid to that employee during the period of disloyalty. But the DOJ's new guidance and pilot program go further. They effectively cover all companies, public and private, large and small. They are not limited to executive officers. They are not limited to any particular form of compensation, and the burden is on employers to figure out how to actually implement and enforce such a policy. So what should companies be considering, and what potential challenges might they face in seeking to claw back compensation? First, companies need to have a clear written policy or written provisions in an employment agreement, incentive comp plan, or award agreement, and be able to establish a record of acknowledgement and agreement by each employee. This will be critical if the company seeks to enforce the policy or provision in litigation. Second, companies need to carefully scope any clawback policy. Who does the policy apply to? All employees? Only executive officers? What kind of compensation will be covered? Incentive comp, bonuses, deferred comp, or also wages or commissions? Third, what will trigger a clawback? How broad should the policy be? How objective or subjective will the standard be? And who will be responsible for administering and overseeing the clawback policy and deciding if the conditions for clawback have been met? Fourth, most employees are not going to voluntarily hand back already paid compensation, which had taxes taken out and has likely been spent. They may dispute that the conditions for clawback have been met. For current employees whose employment is not terminated, companies could consider forward-looking reductions or deferrals of compensation. But what about former employees? After an initial demand for repayment, companies may have to resort to litigation or arbitration, the cost of which could exceed the amount the company seeks to claw back. Fifth, employment laws could also pose challenges. Some states, such as New York, California, Massachusetts, and New Jersey, prohibit or place severe limits on an employer's ability to make deductions from an employee's wages or require repayment of wages, even where the employer receives consent from the employee. And what about employees based outside the United States? Some countries prohibit clawbacks, and others, like Portugal and Germany, limit their applicability to only senior or managerial employees. While the benefits of a compensation clawback policy may outweigh the costs, it is going to require a lot of careful planning and analysis to be both effective and enforceable. For more thoughts on this subject, please be sure to read our advisory, available on the compliance page of our website, and stay tuned for another exciting edition of Critical Compliance.